Good morning, Mr. Patton.
Good morning, Your Honor. May it please the Court.
You're going to help us solve all these problems, Mr. Patton?
I'm sorry, Your
You're
Honor.
going to help us solve all these problems, I assume, in 15 minutes?
I'll attempt to. Let me say at the outset, Your Honor, if I may, just addressing the question that was raised in the prior case in light of the fact of the pending McDonald case down at the U.S. Supreme Court. My position would be that this Court ought to decide that issue. And the reason why
Which issue?
Which issue?
The issue, I'm sorry, on the question of the Second Amendment incorporation. Okay. And the reason I say that is that certainly it appears that eventually, sometime this term, the Supreme Court will make a decision in that case. That's fine. However, we at this point have a situation where there are people, such as my client, who are laboring under a conviction. There are other people that, on a daily basis, I think it's fair to say, are arrested and charged with this offense, and people sitting awaiting trial who haven't been able to make bail. So it has a very real, present effect. If the issue is decided one way or the other by this Court, then a party who takes issue with that certainly is in the position to file for certiorari at the U.S. Supreme Court. If prior to that is acted on, there's a decision that comes down in McDonald, well, then that will have its effect. But the appellate process will have worked, and it will have worked in recognition of the type of right that is actually under consideration when it comes to the Second Amendment as articulated by Heller. Regardless of whatever policy distaste anybody might have to the decision in Heller, the fact of the matter is that the right is articulated there. The Second Amendment right is a specifically enumerated, pre-existing, individual right, the core of which, according to the Court, is the concept of self-defense, and which also carries the additional factor which it shares with the First Amendment, that the behavior that is protected by that right is not reactive to an action by the government, such as a search and seizure or whatnot, but rather it is behavior that the amendment assumes that a person has the discretion to engage in without any government permission, such that any limitation on that behavior is the exception, not the rule, and that any limitation on that behavior requires strict scrutiny under the various the process by which that has been developed over the years, that standard.
So is it your view that any requirement of licensing to carry a firearm is unconstitutional?
My position is that the Massachusetts licensing statute, which requires that any person, for any reason whatsoever, who wants to exercise that right has to first be licensed from the state. And in that sense, it is the same as those situations where the attempt was made to require any person who wanted to exercise their First Amendment right.
Well, but speaking isn't dangerous. Specifically allow for regulation?
It allows for regulation, but I believe the question is, what is the extent of that regulation? And
so having a license requirement, you say we can't do that.
I'm saying that there can be licensing requirements, apparently from what Heller says, but that they have to be circumscribed. They cannot say, before you can exercise this particular individual right in any way, you first have to be licensed by the state to do so.
What do they have to say then?
What Heller points out is that it's okay to have restrictions on certain types of individuals. It mentions felons.
And the mentally ill.
I'm sorry? Yeah?
And the mentally ill.
And the mentally ill.
And so how are we supposed to know who the mentally ill are?
Well, this is a difficulty with the statute that presently stands. When it comes to mentally ill, what subsection D of Section 131 does, it puts the burden on a person who any time in their life had any type of inpatient mental treatment. It puts the burden on them to demonstrate that they're no longer mentally ill. Yet this is what I argue is a fundamental right, and consequently the burden as to that particular provision, and I believe any other provision, should be on the government to, in the first instance, be able to show that for some reason this person is should be considered mentally ill, and not just mentally ill, but mentally ill in which they present a danger.
What's the practical consequence of your, I mean, assume you're right. Let's look at the world that you've created or that Heller's created. A person goes to a gun shop to purchase a gun. There's no license requirement because that's unconstitutional. How is the gun dealer supposed to know whether or not to sell a gun to that person if he can't show a license to say, I've been licensed to possess this gun?
Because this comes back to, again, when it comes to sale of firearms, certainly there can be restrictions on how they're sold, on reporting requirements, etc. But in terms of that individual, in the first instance, just as any individual off the street, saying that before you can walk in and purchase a gun or possess a gun or carry a gun, you first have to go to the state.
So you're suggesting that the license or the seller, there could be a law saying it's illegal for sellers to sell to felons, mentally ill people, in a whole series of categories, but you're sort of at your own risk because there's no way that you as a seller can know that. Well,
Again, that becomes a question of what sanctions are going to be put on the seller as opposed to the individual. If an individual is, again, within a particular category, felon or whatnot, certainly then that person can be sanctioned, as we do with any criminal sanction.
Okay, but I mean, is the seller supposed to call for a psychiatric examination of each person who's buying it to determine whether or not the person's mentally ill?
No, what I'm saying is that what needs to be done, consistent with that fundamental right, is that a restriction can be placed on a person as to whether or not they can purchase because of a specific condition.
So you're saying that you can say you can have a quote licensing procedure, but limited to whether or not you are a felon or are mentally ill, but you can't have a licensing procedure that says nobody under the age of 18 or if you've been, convicted of misdemeanors or whatever the other requirements for the license might be. Is that your point?
Well, what I'm saying is that when it comes to the age or even when it comes to a misdemeanor question, what I'm saying is that the legislature in the first instance could choose to put restrictions. Whether or not those restrictions would stand relative to a strict scrutiny analysis is another question. I think that what we have at the present moment, the difficulty is that when Section 131 was enacted, it specifically was not enacted with the idea that it was affecting a fundamental constitutional right or any other constitutional right. It was enacted on the assumption that what was being restricted was a privilege, whereas now with Heller, we find that it was restricting a fundamental right, and that consequently it can't be assumed that any of the categorizations within subsection D comport with a strict scrutiny standard.
Mr. Patton, your time is getting near, and I wanted to ask you about the Melendez-Diaz question. In this case, apart from the certificate, the ballistic certificate, was there any other evidence that this gun was a firearm?
There was no other evidence. What you have in this case is a gun is found. The evidence of it being a firearm is that certificate.
But you had the spent projectile in the gun.
Right.
But when it comes to the projectile, that is an assumption as to whether or not that had been a live round, or had it just been somebody put in an empty projectile?
Assumption or an inference?
I think an assumption.
Weren't there both live rounds and the spent projectile in this gun?
I'm sorry.
I'm sorry, weren't there some live rounds and the spent projectile?
There were some, quote-unquote, live rounds. But again, they were never proved to be live rounds except by the certificate. And the problem with that is...
Well, that's not proof either. I mean, but can't you, as Justice Cordy just said, draw the inference?
I think that what the problem with drawing the inference from looking at something that looks like a gun, feels like a gun, appears to be a gun.
And guess what is a gun?
Or where you have a piece of ammunition, right, is that it then starts to conflict with, that's all you have. It conflicts with the very idea of why the examination requirement certificate was established in the first place. Because the rationale behind that is that whether it be a gun or whether it be what appears to be a bullet is actually what it is.
Well, the examination sort of takes it out of the realm of doubt. I mean, it's just a very efficient way of doing it. But we have said time and again that a loaded firearm, a jury, without expert evidence, is permitted to infer that it is a firearm under the statute.
But again, the question of the inference, the problem with that is that when you have, if I have a bullet, what looks to be a bullet, if that's all the evidence that I have, and I, as an individual, probably will infer, yes, that's a bullet. But I don't know. It's a technical issue.
Mr. Patton, I hate to the date sometimes. Is this post-Verdi? Are you post-Verdi?
Yes.
And you say harmless beyond a reasonable doubt? And you say harmless beyond a reasonable doubt rather than substantial risk?
Yes, and I will point out that I did object.
This is the one, yeah, okay.
I specifically objected
Okay.
to this.
Thank you,
Thank you.
Mr. Patton. You may not have solved all of our problems, but...
Thank you.
Ms. Eisenhower.
Good morning. May it please the Court. Rachel Eisenhower for the Commonwealth. I would point out that although this is after Verdi, it is 5 months after cert was granted in Melendez-Diaz. And Mr. Patton's objection never mentioned Melendez-Diaz, never mentioned Verdi, never mentioned confrontation, never mentioned the Sixth Amendment, and did not actually even mention hearsay. Rather, he said, we don't know what happened at the state police.
Oh.
His was a chain of custody. He was asking certain inferences to be drawn from that the chain of custody alone did not establish that this was what happened in the testing procedure.
That's the way that I have interpreted the objection. My colleagues have interpreted the objection.
No, I understand that, but let's give it a reasonable, he's saying, I don't know, if I had somebody here, I would be able to ask them. Isn't that what he's saying?
Well, he is saying...
I don't want to take up too much time. We can decide whether there was an objection or not, but I mean, it seems to me, you don't have to use the code words. You don't have to say Melendez-Diaz, Verdi, anything else. But he was saying, I took it that he was saying, if I had that guy here, I could ask him some questions here.
In the interest of time, we'll rest on the brief on that issue. But
Okay.
turning to the Second Amendment issue, you asked in the preceding case, what should this court do with the McDonald versus Chicago case probably coming down next spring or summer? There are cases where this court has declined to decide what standard it is deciding a case under, and yet said that under either applicable standard, the evidence was sufficient, there was no error. So there is precedent for...
I understand that. So let's assume we do that, right? And I look at Justice Scalia's opinion as to the type of regulation that he seems to think is okay. Clearly, categories of people. He doesn't say children, but so if this was a thing saying anybody under the age of 15 can't carry a gun, I'd feel sort of comfortable with that. They're not felons, they're not mentally ill, but okay. Places, so you can't have them in a school, a government building. I don't know why government buildings are more protected than the private side, but nevertheless, so this is in a government building. And then you can say to commercial salespeople, you've got to keep lists, or you've got to make sure that somebody's a Commonwealth, I don't know, list of things, but you can't say you've got to have a license. Can't say that. Too broad. Okay.
I disagree that the Heller opinion said that licensing
No,
generally.
I'm repeating Mr. Patton's argument, and I'm saying Heller doesn't mention a blanket across the board. Everybody's got to be like. I'm just telling you what's not in Heller, and then he gets into do you have to have muskets or can you have nuclear weapons? And he comes down. You don't have to have muskets, but nuclear weapons don't seem to be. Then you get rid of the first piece. But there's really nothing there that says a kind of broad licensing scheme is permissible.
Nor does he say it's impermissible.
No, but he was told by his, dissenting justices what they were interested in. And then, as you heard in the first argument, when you look at the trigger lock, impossible, I don't know if it's impossible. So I'd ask you to address two things, the licensing and the trigger lock provisions.
The trigger lock position, although it's not raised in the DePina case, I think clearly survives Heller because it does not require a trigger lock when it is under your control, is my understanding of that provision.
Okay.
The way I understand it, if you are a person who isn't currently in fear of your safety, or even if you're not, you can sit at the dinner table with your unlocked pistol, shotgun, what have you, black powder, musket, anything that you want, and you are allowed to sit with that fully loaded at the dinner table, even pointed at the front door. And as long as you are there with it, that is not a problem under Massachusetts law. Now, as for...
Can it be on the buffet?
It can be anywhere you want, as long as it's in Lexington. But as for the licensing scheme generally, I would point out that Heller itself only addressed the in-the-home application of the Second Amendment. Now, the right is both to keep and bear arms, and they did make clear that there was some right to carry it outside of the home. However, Heller did not analyze the scope outside of the home. So it is entirely possible, my brother keeps analogizing to the First Amendment, that the nature of the right is different in its different contexts, as it is in the First Amendment context. That the breadth of limitation which would constitute an infringement of your right in the home may not be the same as the kind of limitation which would trouble your right outside of the home. So
let me ask you this. Schools was one of the places, right?
Yes.
That Justice Scalia mentioned. It's pretty obvious why you shouldn't be able to carry weapons in schools, right? So what if there's a Massachusetts regulation, not at issue here, but if you're trying to save different pieces, that says if you've got children who live in the home, your weapons have got to, be subject to all of this, or if you've got children who visit in the home.
So are you suggesting that it would be the current Massachusetts storage regulation, but limited only to individuals with children?
With children in the home, not with children. There could be children living in the home, children living in the apartment complex, children who visit. I mean, we're trying to keep some places safe because children are there. That seems to be okay. Right?
That would certainly be one way to approach the law, but I see nothing. I think before you get to the issue of narrowly prescribing or circumscribing rather laws to make sure that they're narrowly tailored, assuming that we're even in strict scrutiny, which
I'm taking your invitation. I'm going to say it's incorporated, fundamental right, strict scrutiny.
Well, I'm not sure that was my invitation, but
well, you were saying under any standard. Well, then I've got to look at the highest standard, don't I?
You do.
Okay.
You do, but that presents an interesting problem because under the cases in which you've analyzed under various standards and said, well, it meets the highest, those have all assumed that it would be within your power to analyze the issue if you found that it was not within your highest.
That's
and
correct.
What if you come to the conclusion that it does not meet strict scrutiny? What is the court to do? Is it to issue an academic opinion saying this does not meet strict scrutiny? Isn't it interesting that Crookshank hasn't been overruled? Or are you to say...
Well, we can't overrule Crookshank. You know that, right?
We've discussed this previously. But But I think it puts the court in a difficult position to undertake the analysis where if you find that it survives all levels of scrutiny, you can issue the opinion and sort of bless the Massachusetts statute in advance and save us all the litigation. Or you can say, well, we're not sure and we're going to wait. And it's kind of hard to undertake the analysis when one of the possible answers isn't really within the court's current authority and purview.
That's a good argument not to decide the case right now.
It is a possible argument not to decide the case. I mean, if there
But does that mean that we should be staying all prosecutions? I mean, we have other liberty interests at issue, so does that mean to say we stay all prosecutions and you can't incarcerate people?
There are prudential concerns going both ways. I would say that the Massachusetts criminal laws retain their validity, and certainly prosecutions should continue under them until that there is a sign that it's suspect. I think that
Well, there's a sign.
Well, I meant more than a sign.
Sure.
Perhaps a binding Supreme Court precedent would be
Sure.
a nice sign. But
Well, isn't the question here whether any licensing is constitutional? Because he didn't apply for a license. The issue before us is not whether or not there was some abuse of discretion in denying him a license. He was arrested without a license.
That's true. And it's perhaps...
So isn't all we need to determine as to whether the licensing of firearms is permissible under Heller, or must we do more than that?
You mean any licensing, limited licensing or broad licensing?
Just
He
any
doesn't,
license.
Justice Cants would say, I don't care, because the burden was on the defendant to say, I didn't apply for a license because I don't know how old your client is, Mr. Patton, but
He's
I'm
17 at the time of the incident.
17, so, okay.
So he couldn't have had a license
He could not have had a license at the time of the incident.
under
However,
our law.
I believe under Massachusetts law, it becomes a facial challenge rather than an as-applied challenge. So I'm not sure that his age is actually relevant to his challenge.
But can you go what I take Justice Gans is suggesting, which is I don't have to, in your case, I don't have to define the outer limits of what licensing, what across-the-board licensing would require. Because I don't have, here I just have an unlicensed one.
Well, the only case I've found on this issue is the case cited by the defendant in which there was a food seller in downtown Boston. I believe it might be Gordon,
Yeah.
perhaps. Yes, the Gordon case and cases cited. So if you read those cases to allow mere review of the fact of a licensing scheme, then I would say that Justice Gantz's approach is a perfectly fine one. I didn't analyze those cases with that question in mind, so I actually can't give you a good answer on that. But I think that whatever the Massachusetts case law from that line says will answer Justice Gantz's question. And if you can distinguish from that cases and explain why this really just asks about the fact of a licensing scheme, then it's certainly a valid approach to say, well, a licensing scheme is valid, 10A prosecutions shall continue until Heller. I mean, I think that staying all prosecutions I have questions about like where the constitutional authority to do that would come from. So,
Let me ask you this may be a question that's born out of ignorance, but if you assume hypothetically that Heller would say it is impermissible to have an across-the-board licensing scheme, but if the core right is about self-defense, and particularly in the home, you can license the use of firearms for use outside the home. Is there an argument that if you have, as in this case, the facts are that the gun was used, not only was it not licensed, but it was used outside the home, would that get you anywhere, or is because the statute is totally, I mean, the licensing statute covers everything, does that?
well, first of all, to be fair, we never got into evidence that he used the gun. All we have is that he carried the gun.
Right, but it was out. I just meant
but
it was no
yes.
connection to a home.
Yes, no connection to the home. At the very least, there is language in Heller that that the self-defense right will extend outside the home, but that is dicta. The holding only went to the home itself. At the very least, I would say that it might be a different standard of review for inside versus outside. And to some extent, and I recognize my time is up, so
No, you can answer the question.
If the right were limited to the home, the question of whether one could license it outside the home would have no relevance because it doesn't limit the right at all. If the right's only over here, the law dealing with what happens out here doesn't actually impact the right at all. So it's sort of like saying that conduct is not speech and then asking whether something would violate the First Amendment that regulates it. So if there are no further questions, I recognize that I am well over my time limit, so thank you very much.
Thank you. Commonwealth versus what?